Hello, and I hope everyone has had a good week. And if you recall the last discussion we had, we talked a little bit about that whole concept that I said we were going to address, which was guilty, not guilty, that whole idea of innocent, which really doesn't mean anything in the legal profession, in the trial setting. And we talked about burden of proof, beyond a reasonable doubt, presumption of innocence. And today I thought what we would talk a little bit more about is the concept of the burden of proof and beyond a reasonable doubt. Because in order to understand the difference between guilty and not guilty, it's important to have a firm feeling for proof beyond a reasonable doubt in the context of what someone may be accused of. So I'm going to try to take a very simple set of facts to talk about with you and kind of give you an example of where guilty might lead to and not guilty may end up. So let's say, for instance, in the state of Indiana, you're charged with battery. Now, battery is knowingly, intentionally touching another person in a rude, insolent, or angry manner. So the government, if they accuse you of battery, the state of Indiana has this obligation to prove your guilt on each element beyond a reasonable doubt. So what that means is that they have to prove beyond a reasonable doubt that you knowingly and intentionally touched another person, in a rude, insolent, or angry manner. Now, there's a whole lot of things that spin around out of that. There's defenses, but there's the difference between battery and knowledge and knowing and recklessness. I just want to focus on, if the government accused you of knowingly and intentionally touching someone in a rude, insolent, or angry manner, that's battery, what it means to be obligated by the law, the Constitution, to prove each element beyond a reasonable doubt. So the government has to start out and they have to prove that you knowingly touched somebody, which means that my action of whatever, pushing, striking that person, it had to be knowing and intentional. That I knowingly and intentionally hit someone, and that when I did it, that it was in a rude, insolent, or angry manner. So when you're looking at that in the context of a trial, potentially, then you start thinking about these things. Well, okay, so they can prove that I touched someone by that someone testifying. And they can say, well, Wilder touched me, and that's my testimony. And he touched me and he was mad and he was angry and he did it and he was rude and he battered me. He touched me in a rude, insolent, or angry manner. Government proved all of those elements beyond a reasonable doubt. So now let's think about it this way. So it's someone who says, I did that. And that's all the evidence. Their word. And there's no video. There's no physical injury that's been evidenced by photographs. There is no evidence of any other witnesses. It's Joe Blow saying Wilder touched me in a rude, insolent, and angry manner. And it's just his word. And let's add another fact. I don't even know Joe Blow. I don't know him from Joe Blow. So someone I don't know says I touched them in a rude, insolent, and angry manner. We go to trial. At trial, the government would have the obligation to prove to the jury beyond all reasonable doubt that I touched Joe Blow in a rude, insolent, or angry manner. So you just start with that story by that guy, and there's nothing else but his story. Well, jury gets to decide whether that story's enough, whether that's beyond a reasonable doubt. Now, let's assume there's no evidence, and let's assume that I really did touch Joe Blow in a rude, insolent, and angry manner, and it's just me and him, and I didn't know him from Joe Blow, but I shoved him because I was mad because he got in my way, and I don't make that statement, and I don't tell anybody that I even did it. I could be guilty, but there would be no evidence in many ways to prove that I was guilty beyond all reasonable doubt. Because the story itself might not be in the minds of a jury, of jurors, enough evidence to prove guilt of knowingly, intentionally touching in a rude, insolent, or angry manner. And I may be guilty, but the jury sitting there should probably go, well, this is just one story and we're not hearing another story because I don't make a statement to the police. I exercise my right to the Fifth Amendment, and we'll talk about that, the effects of that, how hard it is to get jurors to accept that it's okay for people not to stand up and say, I'm not guilty. But let's just assume. That's it. That's all it is. A story. Is that story enough to prove guilt beyond all reasonable doubt? Let's go to the next piece of it. Let's say, same story, but Joe Blow calls the police come, they take Joe's statement. Joe says Wilder pushed me, knocked me down, and he knocked me down over there in the corner. And look, over there in the corner you can see there's things that are broken, and I fell on those things, and those are the things I fell on. And here's my arm that's got a little cut on it, and it's from breaking those things. Well, now you've got evidence of Joe Blow's story. There's some physical evidence. There's a picture of an injury. There's a picture of broken furniture over in a corner where Joe says I shoved him down. So now you've got a little more evidence. But then throw in there that I made a statement that I didn't listen to my lawyer. I didn't exercise my Fifth Amendment right, and I made a statement. And my statement was, well, we were dancing, and I swung my arms around because that's how I dance, because I'm really a bad dancer. And Joe was standing near me, I guess, and when I swung around, I hit him, and I didn't mean to. It wasn't intentional. And he fell. And when he fell in that corner, yeah. But I didn't knowingly and intentionally, in a rude, insolent, or angry manner, strike him. So, gosh, I mean, yeah, I hate what happened, but I didn't commit that crime. So then you got the jury who has to sit there and go, okay, do we believe Wilder? Do we believe Joe Blow? Are they both reasonable stories? What's the evidence? And has the government proven that Wilder knowingly, intentionally touched Joe Blow in a rude, insolent, and angry manner? Or was it what Wilder said? He's a really bad dancer, and there were other people there. There was a party. Now, the other people didn't see anything, or we didn't get any statements, but there was a party, and he just knocked him down by accident. So what are we going to believe? And that's what the jury does. They make those decisions. So we kind of have to look at it in those terms when we're thinking about what is beyond a reasonable doubt, and then how can someone be guilty? And that's the state proves every element of a crime, knowingly, intentionally touched in a rude, insolent, angry manner, beyond a reasonable doubt, or how a jury can come back and say not guilty based upon the same set of facts, but that the jury doesn't believe that there's been proof beyond all reasonable doubt that Wilder touched him in a rude, insolent, and angry manner, because, there's a chance he's a bad dancer. There's a chance that in the midst of this celebration, he accidentally knocked him down. There's a potential, maybe that's what happened. Well, if there's the ability to say maybe that's what happened, then that is the reasonable doubt. Because reasonable doubt, it's the absolute protection we have to have. That if beyond a reasonable doubt, the proof must be presented, then we don't run the risk of people who have, first set of facts, no evidence at all. Joe Blow says I just shoved him. Well, is that just enough on its own? So, that story could go either way. Now the jury could come back and say, Wilder was sitting there and he looked like a horse's ass. And he seemed like he was mad all the time and he's an angry guy. And he probably did that. That's not enough, probably. probably did it, likely did it, maybe did it. That's not what it is. It's must be convinced beyond all reasonable doubt that that is what happened. Now, on the other set of facts where we added the dancing and the, hey gosh, it was an accident part, then the jury may have had an opportunity to go, well, that story doesn't make sense. Because if you're dancing and it was an accident, gosh, how bad of a dancer do you have to be to knock a guy over in a corner? You must be a pretty bad dancer, so we're going to call BS on that story. We believe that he's not telling the truth, and we believe that Joe Blow is telling the truth because he had injuries, he got touched. Wilder admitted he touched him. Now, he claims it was an accident, but the facts and the story don't lend to his defense. What it does is it lends to the idea that Wilder touched him in a rude, insolent, angry manner beyond a reasonable doubt. And that's guilty. So you see, facts can in turn result in not guilty verdicts, when in some instances someone may be guilty. But it's important to understand that if there's a doubt, if there's a reasonable doubt that a person is guilty, they must be found not guilty. So when you are looking at verdicts and you're going, well, how in the world did that crazy bunch of people in LA County find O.J. Simpson not guilty? You got to remember that verdict wasn't that O.J. Simpson was innocent. That verdict of not guilty of my dancing around and knocking Joe Blow down story, finding me not guilty, doesn't mean that they're finding me innocent. What that means is that they're finding that the government did not prove each fact beyond all reasonable doubt such that the Constitution allows for us to find that person guilty, take their freedom, stigmatize them for life, and making them criminals. So there's a difference between not guilty and innocent. And that's sometimes the disconnect. People sometimes believe that a jury's decision to find someone not guilty is a proclamation of innocence. And then the world beyond the courthouse sometimes goes, well, how in the hell did that bunch of knucklehead citizens not find him guilty, because we know these facts. And these were facts that were out there and nobody disputed those facts. Well, those facts sometimes aren't enough to prove beyond a reasonable doubt someone committed a crime. And a responsible jury, a good group of people who understand how important it is for all of us to have the ability to be presumed innocent, and that the government must prove our guilt beyond all reasonable doubt, will find someone not guilty. And this protects innocent people. So when you are looking at and listening to and hearing verdicts from different juries across the country, I can't speak for the rest of the world because I don't know all of their systems, but when you hear in this country someone is found not guilty, what you have to say to yourself is this: they are not guilty because a group of people just like me, citizens, peers, heard every bit of evidence that the government presented, and the government was unable to prove the facts they had to prove beyond a reasonable doubt for that jury to determine a person is guilty. And remember, guilty and not guilty doesn't equate to innocence. What it means is our system works. And the system works because we are not going to become that country that, based upon mere accusation, merely because a story sounds like it should be something we should believe, and we put somebody in prison over that. We demand that the government, before they take our freedom, prove every allegation beyond a reasonable doubt. Now, I'm a little longer than usual, but I'm going to finish up by saying this. And to make yourself comfortable with why that's so important, you gotta put yourself in another person's shoes. We can't say that at trial. We can't say that when we're picking the jury, but while we're sitting at home after watching this, put yourself in another person's shoes and say, how many times have I been in a situation where what was going on and what happened on its face may have led someone to a different conclusion, and I surely wouldn't wanted the conclusion that just how it appeared to be something that someone beyond all reasonable doubt believed. What I want the presumption of innocence to apply to me, and what I want the government to have to prove that I did things that they have accused me of beyond all reasonable doubt, and not be able to rely on just innuendo, what looks right, what may or may not have happened, and what I think probably happened beyond all reasonable doubt. So that kind of is a long-winded way, 15 minutes, long-winded way to talk about not guilty, guilty, and innocence. The next thing I would like to maybe address as we move along are some of the concepts that go along with the idea of the Fifth Amendment, your right to remain silent, and talk a little bit about how that affects the outcomes of trials and how jurors sometimes answer questions about that. So, wrap up by saying a couple things. First, I'm just here talking. This is not legal advice by no means. Everybody should hire their own lawyer. Don't take this to mean I'm giving you legal advice. We're just talking about the law, because I am Larry the Law Guy, Larry Wilder, attorney, and I thank you very much and I appreciate you listening, and hopefully the next time I'll get in under that 10-minute mark. Thank you.